Welcome, sir. Please be seated. Good evening, one and all. Myself, Krishna Navnath Bhosle, and I am delighted to be host of today's program. It is great honor and privilege to welcome you all for the lecture series program organized by Advocate Association of Bombay High Court, bench at Aurangabad. Today, we are glad to have with us Senior Advocate V.D. Sapkal sir as our speaker for the second lecture in a lecture series program on the topic of drafting and pleading. As a token of appreciation and gratitude, I now request Mr. Avinash Borulkar sir, President of our Bar Association, to felicitate our today's speaker, Senior Advocate V.D. Sapkal sir. Thank you, sir. Moving forward with the program, I call upon Mr. Ravindra Gore sir, Secretary of our Bar Association, to give brief introduction about the intent for conducting the lecture series. Please, sir.
आदरणीय व्यासपीठ आणि सभागृहात उपस्थित सर्व श्रोत्यांना नमस्कार. आपल्या लेक्चर सिरीजचे दुसरं पुष्प, आपल्या अभ्यास व्याख्यानमालेचं दुसरं पुष्प आदरणीय ज्येष्ठ विधिज्ञ सपकाळ साहेब आज गुंफणार आहेत आणि त्यासाठी उपस्थित सर्व मान्यवरांना नमस्कार. खरं तर इंट्रोडक्शनच्या अगोदर एक छोटासा योगायोग सांगतो. 2010 साली जेव्हा आदरणीय सपकाळ साहेब आपल्या वकील संघाचे अध्यक्ष होते, वन फाईन मॉर्निंग त्यांचा फोन आला, आदेश आला की त्यावेळेस आपल्याकडे मुंबईहून व्हिजिटिंग जज जस्टिस म्हात्रे आणि जस्टिस वजीरदार आले होते आणि त्यांचं स्वागत वकील संघातर्फे होतं आणि सरांचा आदेश आला की हा कार्यक्रम आहे आणि तुम्ही अँकरिंग करणार आहात, वोट ऑफ थँक्स करणार आहे. मला आणि गजानन क्षीरसागरला फोन आला. 2010चा तो दिवस आणि 2024 साली मी स्वतः सचिव म्हणून सरांकडे गेलो. सरांना रिक्वेस्ट केली, सर लेक्चर सिरीज आहे आणि तुम्हाला मी निमंत्रित करतो आहे स्पीकर म्हणून. तर विद्यार्थी आणि शिक्षकाचं हे जे वर्तुळ आहे ते आज पूर्ण झालं असं मला वाटतं. MP लॉ कॉलेजमध्ये असताना सर आमचे शिक्षक होते. ते शिक्षक गुरुचं जे नातं आहे विद्यार्थ्याचं ते कंटिन्यू आहे. आणि आपल्या व्यवसायात एक म्हण आहे, लॉयर्स अँड डॉक्टर्स आर नॉट परफेक्ट बिकॉज दे आर ऑलवेज प्रॅक्टिसिंग. तर शिकण्याची ही प्रक्रिया आहे आपली शेवटपर्यंत आहे. त्यामुळं जो 1 वर्षाचा वकील आहे, ज्याची प्रॅक्टिस 1 वर्षाची आणि याची 40 वर्षाची आहे, प्रत्येकजण दररोज शिकत असतो आणि ही शिकण्याची प्रक्रिया असते आणि ही चालू असते. आणि आपल्या वकील संघाचा इतिहास आहे 40 वर्षाचा. ही लेक्चर सिरीज तेव्हापासून चालू आहे. आणि जेव्हा ही लेक्चर सिरीज आपण सुरू केली माझ्या कमिटीने, जेव्हा आम्ही चार्ज घेतला, त्यात वेगळं काय करता येईल बऱ्याच जणांकडून आपण सूचना घेतल्या. तर आपल्या लेक्चर सिरीजचं स्वरूप कसं आहे, जे 3 प्रकार आहेत. पहिला प्रकार आहे किंवा पहिली कॅटेगरी आहे नो दाय जज. या अंतर्गत जसं पहिलं लेक्चर न्यायमूर्ती घोगे साहेबांचं झालं, म्हणजे स्वतः न्यायमूर्ती महोदय त्यांची जी जर्नी आहे फ्रॉम बार टू बेंच आपल्याला सांगतील आणि त्यातून नवीन जनरेशन किंवा आपण मोटिवेट होऊ, ही त्यामागची भावना आहे. लेक्चर सिरीजमधला जो दुसरी कॅटेगरी आहे, जी लेक्चर जे प्रॉपर लेक्चर आहे ते आपण आज अरेंज केलेलं आहे. ह्या लेक्चर सिरीज अंतर्गत आपल्या खंडपीठातील जे आदरणीय ज्येष्ठ विधिज्ञ आहेत त्यांचे लेक्चर आपण सुरुवातीच्या टप्प्यामध्ये फर्स्ट पार्टमध्ये करतो आहे आणि सेकंड पार्टमध्ये मग आपल्या खंडपीठातील जे एक्सपर्ट लॉयर आहेत, जे चांगले स्पीकर आहेत, त्यांचे लेक्चर आपण ठेवलेले आहेत. आणि जो तिसरा प्रकार आहे हा नवीन आहे, स्टडी सर्कल. जसं तुम्ही बघितलं असेल सुप्रीम कोर्टला फ्रायडे ग्रुप आहे, त्याप्रमाणे स्टडी सर्कलच्या माध्यमातून आपण असा उपक्रम राबवणार आहे. जसं की केशवानंद भारतींचं जजमेंट आहे, त्यावर ग्रुप डिस्कशन आहे. मग आपल्या उच्च न्यायालयातील खंडपीठातील जे अगदी प्रॉमिनंट लॉयर आहेत, जे चांगले स्पीकर आहेत, असं 10 जणांचा एक ग्रुप राहील, ग्रुप डिस्कशन राहील. आणि त्या ग्रुप डिस्कशनमध्ये त्या स्टडी सर्कल अंतर्गत मोस्टली जे नवीन ज्युनियर आहेत ते त्यात पार्टिसिपेट करतील आणि या सर्व गोष्टींचं आपण यूट्यूबवरती स्ट्रीमिंग करणार आहोत. त्यामुळे ही लेक्चर सिरीज 3 पार्टमध्ये आहे आणि आता याचं आपण दुसरं पुष्प आदरणीय सपकाळ साहेबांच्या माध्यमातून गुंफणार आहोत. तर लेक्चर सिरीजच्या मागची भावना काय आहे माहिती का, की जो नवीन लॉयर असतो किंवा जो फर्स्ट जनरेशन लॉयर आहे त्याला मोटिवेट करण्यासाठी, त्याला नवीन गोष्टींच्या बाबतीत अपडेट करण्यासाठी हा वकील संघाचा एक छोटासा प्रयत्न आहे. आणि यामध्ये माझी जे आज नवीन ज्युनियर आहेत, ज्यांची प्रॅक्टिस लेस दॅन 6 इयर्स, अशा सर्व ज्युनियर्सला कळकळीची विनंती आहे की तुम्ही आज जे प्रेझेंट आहात, नेक्स्ट टाईम तुमचे जे कलिग्ज आहेत त्यांना सगळ्यांनासुद्धा हजर राहायला सांगा, जेणेकरून नवीन ज्युनियरसाठी हे आहे. हे बघा, प्रत्येकजण विद्यार्थी आहे. ज्याची प्रॅक्टिस 20 वर्षाची तो पण विद्यार्थी आहे, ज्याची प्रॅक्टिस 2 वर्षाची तो पण विद्यार्थी आहे. परंतु प्रत्येकासाठी आहे, तरी ज्युनियर वकिलांनी यात जास्तीत जास्त सहभाग घ्यावा अशी वकील संघाची इच्छा आहे. एवढं सांगून माझं इंट्रोडक्शन संपवतो. धन्यवाद.
Thank you, sir. Today we are privileged to have with us Senior Advocate Mr. Vijay Kumar Damodar Sapkal, sir, for our second lecture on topic of drafting and pleadings. Sir, born in 1966, sir has completed his BSL LLB from Pune University in first class. Having dazzling academic career, sir got enrolled an advocate with Bar Council of Maharashtra and Goa in year 1989. During his 35 years of period of advocacy, sir has conducted various civil, criminal, constitutional, election, service and tenancy matters. Sir was also elected as a president of our Bar Association in the year 2010, Senior Division at Aurangabad. A distinguished lawyer, luxurious academician, having plenty of reported judgment, Advocate Vijay Kumar Damodar Sapkal, sir, was designated as Senior Advocate by Honorable High Court of Bombay in the year 2020. Sir, today we are fortunate to have you amongst us. I request now Senior Advocate Mr. Sapkal, sir, to address the gathering. Please, sir.
President Mr. Burulkar, Secretary Mr. Gore, and all my friends at the bar. Today, it is a pleasure for me to appear before me as a student of law and have some discussion with you on a subject of drafting and pleading. Now, it is very difficult for me to say something to a lawyer because lawyer will not listen to anyone. It is a fact, because I am a lawyer, I know. This is a quality of everybody. But even then, I'm trying to put some my past experience so that you'll get some clue that how we can develop our drafting. Now, I'm doing this for a reason that since 2020 onwards, I lost the opportunity to draft a petition. Or I'm saved from a criticism that nobody can ask that who has drafted this petition, because I can find out the faults of the draftsman only. And therefore today, with all courage, I am standing before you. Friends, just now my friend has introduced and he told that Mr. Sapkal got first class from Pune University. It's a fact. I may tell you, there is one more fact, that I got only 47% mark in a 12th examination. Reason is this, that there are so many students like me, they will try to comparison that if a 47% mark in a 12th examination can stand before us and teach something, then we are far better. And that is the only reason that I am telling you that I got only 47 marks in a 12th. There was a rule for pre-law admission that those who have achieved only 45% mark, they are entitled to get an admission. And I was saved because of 2%. I got admission and I am here with Nirgudkar. And you have to mention two matters. Requesting the court that my senior is held up in another court and therefore please keep the matter back. This was a request to be made. I was not aware any tradition of High Court at the relevant time. I was not aware of protocol. Then I asked my colleague that exactly what I have to do before the court. Then he told me that you have to go and mention. I told him that I am not good in Marathi, I am not good in English. What I can mention before the court, tell me that. And he told me that you have to go before a court, make a request. Sir, my senior is engaged before court number 1 and therefore please keep the matter back. I wrote down, and this was the first drafting of a law in my life. I wrote down And that was first good drafting, because I read whatever I have written on a paper and I expressed before the court, my lord, my senior is held up before court number 1, please keep the matter back. And then matter was kept back. After 2 matters, there was one more matter. And I was directed my immediate senior that you have to mention that matter also. This was the first instruction given. I was not aware that whenever second matter is called, again you have to go and mention before the court, and same request is made. I was standing aside, matter was called out, and Justice Nirgudkar passed an order, none present, dismiss in default. I was not in a position to understand what is the exact order passed by the court. What is the meaning of this dismiss in default? This was a position in 1989. Then my immediate senior came, you have not mentioned this matter, matter is dismissed. But he was kind enough with me. He took me to the chamber of a learned judge in the afternoon session and requested that he is appearing first time before the court and this mistake occurred from him. The learned judge have to exactly mention before the court for restoration. And then I asked my immediate senior that what I should mention before the court for restoration. And he told me that you have to mention before a court requesting that my senior was held up. I was instructed to appear before the court and seek adjournment. And I felt, because I was under impression that earlier matter is mentioned, and therefore it is my fault, client should not suffer for this fault, and please restore the matter. Now all these sentences, it was very difficult for me to grasp and then mention before the court. Then I asked him, wait, I'll take down all this. I took down everything, and then I went before a court. I mentioned the same thing what was there in a draft. This was a second draft in my petition, in my life, and that was an excellent draft for the reason that matter was restored. There are 2 things, that my presentation was as per the draft which is written. Why I am telling this, matter was restored, but I was very happy that I was not aware anything. Still, I got relief on the basis of draft which was dictated by my immediate senior, and I was very happy. Thereafter, I started learning the law along with my friend. I used to observe. This is for this reason why the drafting is important in our life. Because there are so many things, what we are facing today before the court, that we argue one thing which is not there in a petition. Reason is, instructions are given by a client, but that is either not properly appreciated by a lawyer like us, or that is not properly pleaded in the petition. That is the reason. And there are several times. Today I was just verifying one school tribunal judgment, and I found 7 years a person who was in the employment as a teacher, his services were orally terminated. There was an oral termination, and he went to the school tribunal. The reply was filed by the management, and then judgment came. Now in the judgment, everything is fine. That person, 7 years worked, there is no departmental inquiry conducted. Unless departmental inquiry is conducted, no person can be removed from the post. His thing. The learned judge appreciated everything, but then he observed that the appointment of the teacher is not properly made. We know if there is a civil suit, we cannot adduce the evidence beyond the scope of pleading. That is the settled position of law. Therefore, what is to be seen is best pleading is necessary. Friend, now we have benefits in earlier days in 1989. All facilities were not available when we entered, because these computers, CDs, and artificial intelligence, this was not there. What was the practice? Go through commentary, go through the digest, find out a judgment, and then prepare the case. Now we are doing reverse. papers are received, instructions are taken, petition is drafted, and then we are trying to search the judgment in support of our case. In fact, that is not a practice. I never followed this practice. There is a consistent practice I followed, even I followed today also, that take instructions, find out judgments, what are the judgments available in the field in your favor, what are the judgment against can be made in your pleading. And that is available because of artificial intelligence is there. We have a case mine, we can immediately get various cases or interpretation. We can predict the outcome of a petition easily if everything is available. Now, what is the drafting? Why the drafting is essential? What is the expectation of a judges? Because we find that so many judges are disturbed so many times, and on a dais they are expressing so many things. What are their expectations from us? That is very important. Judges normally expect a good drafting. Even if somebody read the paper, the case should be understood by the judge, so that what is the legal issue can be understood in a better way by the judge. If a petition is read, it would be easy for the respondent to understand what reply is exactly to be filed before the court. Justice Krishna Iyer says that drafting is the art of crafting reality on a paper. This is very important. This is the art of crafting reality on a paper is the drafting. Law exists. We know that law is enacted. It exists in a written form. But if it is molded, then it becomes a justice. And therefore, what is important is necessary. Justice Nariman stressed that importance of clarity in a legal document, stating that complicated language can confuse the court and lead unintended consequences. Therefore, don't use complicated language. There are petitions and there is a habit in the bar and dependence on a good drafting which reflects lawyers' clarity of thought and thus influences the court's perspective. Our thought should be clearly reflected in our pleading first and then in argument. Now, what is this drafting? When we were all in a 10th examination, there was in all subjects, Marathi or English, there was a 10 marks question for letter writing. You have to write a letter to your friend, your brother, so many. Then you have to choose address. What should be the internal portion? Why this exercise? I got clue. This later drafting is not a formality. This is a pleading you have to make so that the other side would exactly understand your feeling, and that is necessary. When you draft a petition, there should be a complete structure of the petition, clear idea, so that judge can get from your pleading that what is exactly in the petition. There should be clarity. Clarity means everything should be clear, unambiguous language. The pleading that is complicated is not an argument but an impediment of justice. This is said by Justice Mishra. Now, why they are saying repeatedly on this, why they are wasting their time on making an observations on the pleading? Because when they hear a petition before any court, they have to concentrate on a pleading. For example, you may notice that so many things are argued, and if a judgment is reserved, in a judgment, you will find that maximum portion, what is there in a pleading, either in a petition or in a written statement, that is reflected. And your arguments are not kept in mind. And then we make a grievance that so many things were argued and not reflected in the judgment. How it can reflect? Unless there is a foundation in the petition, there cannot be a decision by the court on those oral submissions. Then a precision, accuracy of fact, references, legal principle, strengthen your case, and that demonstrate your professional skill also. Therefore, this is all to be followed when a draft is made. why pleading is necessary, why we are giving so much importance. Now, there are two things we know, that in a civil procedure code, there is a separate provisions for a pleading. Order 6, perhaps. In a criminal procedure law, you will not find the law of pleading. It is absent. And therefore, whenever there is a civil petition, we have to focus on a pleading as far as possible. Now, if a petition is clear, then it gives an outlines of the fact and legal grounds on which the petitioner relies. Therefore, when we are relying on a facts, it should be clear. When we are relying on certain grounds, it should be clear. And this clarity helps the court to comprehend the case without ambiguity. What is the case? If it is to be understood in a better way by the court, your pleading should be proper. There is no alternate. Whatever argument best you advance, if there is no foundation, it would be useless. The second thing, it is expectation of a judge to identify the legal issue. Proper pleading helps to identify the specific legal issues at a stake. The assistance of a court in determining the jurisdiction as well. Therefore, if there is no pleading in respect of a jurisdiction, there would be vacuum. That what is the jurisdiction of a court? And the other side would raise a jurisdiction, that this court has no jurisdiction, that court has a jurisdiction. Therefore, when a petition is drafted or a plaint is presented, there should be clear-cut mention that this court has a jurisdiction and why it is to be mentioned in the petition or drafting itself. When you draft the petition or a petition is drafted, judges expect a fair response from the opposite side. And therefore, the clear pleading allows the respondent to prepare adequate defense. Therefore, for this purpose also, the clear, unambiguous drafting is essential. Then establishing a ground for a relief. There should be specific ground. You know, I argued one PIL from my office, which was drafted by my colleague. It was before a Chief Justice. PIL was argued, and it was dismissed within a few minutes. And reason quoted is, under the appellate side rules, if there is a petition, you have to separately make out the grounds, and in your petition there is no ground. Fortunately, the liberty was granted. Therefore, we again drafted a petition with ground, and then the petition is presented. Therefore, these small things, which are very essential, those we have to keep in mind while drafting the petition. In long back, this judgment which is I'm going to refer, on my mind, unless I am satisfied that this drafting is correct or I'll be comfortable while arguing the matter, I'll not approve the draft. Therefore, I do this exercising, settling the draft of my colleague. And this is for this reason. The judgment which is reported in 1998 Supreme Court, I'll refer few paragraphs. From that judgment, the High Court allowed the petition and of the entire, and then matter went in Supreme Court. Supreme Court heard the matter, and Supreme Court allowed the appeal against the order. What are the observations, so that you will understand what is the importance of the pleading? And I'll read for you. In the absence of any allegation that not been complied, and particulars in respect of non-compliance of Rule as to how the High Court could have reached to the finding that the statutory requirement contained in the were not full of notification under Section 4. Therefore, if something is to be alleged, all details, particulars are to be furnished in the petition. Now, this Honorable Supreme Court has observed, since this was not done in a High Court, there was no pleading. How the findings are recorded by the High Court, it is not known. Section 4 and declaration under Section 6 of the Act. High Court did not give any reason as to how it reached the conclusion that Rules 3 and 4 had not been complied in the face of the record of the case, because it is not pleaded, and therefore on the face of record it is absent. The court has said, rather it returned the finding which is unsustainable, that it was not possible on the basis of material on record to hold that there was a compliance of Rule 3 and 4. When there is no pleading, High Court should not have written such finding, and the High Court should not have allowed the petition. That is the observation. In a further part of the judgment, I will not read entire paragraph 10 because it would be boring. And the lawyers, it is very difficult. Even somebody hears the matter, some time goes, and then everybody is disturbed. I'll read only relevant portion for you. In this view of the matter, it is difficult to understand as how the High Court said that there was no compliance with Rule 3 by the state government when, as a matter of fact, as noted above, there was no mention of non-compliance with Rule 9 in the whole body of writ petition. Therefore, since the pleading was absent, there was no option for the Honorable Supreme Court to write a judgment holding that the High Court has committed an error. It was considered that there was no specific averment relating to Rule 3. Even otherwise, we find that a stipulation contained in Rule 3 were fully observed. As a matter of fact, only 2 contentions had been raised by the petitioner before the High Court, and that were that the land belonging to the cooperative housing society, which itself was a public purpose, could not have been subject of acquisition, and that Rule 4 has not been complied with. There were, however, no particulars stated in the petition as to how it could be said, so said. It is not enough to allege that particular rule or any provision has not been complied with. It is a good pleading to give a details that is a particular as to why it is alleged that there is non-compliance with a statutory requirement. Ordinarily, no notice can be taken on such allegation which is devoid of any particulars. No issue can be raised on the plea of foundation of such which is lacking. Now, Supreme Court says that no notice can be taken of such pleading when particulars are not supplied. Now, suppose there is a notice, administrative notice is under challenge or order is under challenge. We normally plead that the principle of natural justice is violated because the rule contemplates that there should be a notice given. Now, what should be the pleading according to me? There should be complete disclosure that we received a notice on so and so date, or there is a mention in the order that notice was issued. The notice is not received by us. Had it been a notice, we could have got an opportunity to explain, but this opportunity is denied by the respondent, and therefore there is a violation of principle of natural justice. By saying this, that there is a violation of principle of natural justice will not make any sense in the petition, and therefore these all particulars are required to be mentioned in the petition. Now, when we are talking about the pleading, most of us, we are practicing in High Court. We don't focus on a pleading. But friends, we have to always refer Order 6 of CPC for so many reasons, because the pleading is elaborated in this Order 6. Order 6 says that the pleading shall mean plain and written statement. Both. Pleading is plain and written statement. Therefore, whatever written document is submitted before the court for its consideration, it is a pleading. Now, though it is said that plain and written statement, there are so many other applications which are in the form of, for example, Order 6, Rule 17, amendment application, pleading. Now, why there is an amendment, why it is necessary, what are the subsequent facts after filing of suit, those are to be pleaded and then only the court will consider. Law says, or this order says, that pleading shall state material facts and it should be divided in paragraph. Now, this is stated in the law itself. Paragraph doesn't mean that it would start from page number so and it would end on page. It should be small paragraph, and the sentences should be small for the reason to avoid ambiguity. That is essential part of a pleading according to me. The dates, sums, number shall be expressed in word and figure. That is the requirement of a law. We are not following, but in my opinion, that we should see this order and we should follow it. Particulars to be given where necessary. As I said, that only making one sentence of fraud, concealment, breach of trust is not sufficient. We have to give all particulars, that how there is a fraud played. What is the nature of fraud? All such particulars are required to be submitted in the pleading, and that is the law. Then effect of a document which is to be stated or referred. In a writ petition, we are not following the civil procedure code. We refer so many documents and we give exhibit for identification of document. In a civil procedure, when you submit a document before a court along with a plaint, those are the documents submitted with the court. But unless Order 18 Rule 4 is followed, tendering of a document, the document will not be exhibited. What is that procedure is that you identify the document in a witness box and then in a high court there is a difference. We exhibit the document. This is our statement. There should be a particulars given stating that respondent number 1 or 2 has given a notice on so and so date, calling upon the petitioner to explain all these things, and the particulars are 1, 2, 3, those should be mentioned in a petition so that you can refer the document. It is not necessary that you should translate entire document and plead in the petition, not necessary, that is not requirement. Material things are to be explained in the petition. Then if there is a malice, we find several times that when we file a petition, there is always interference by a politician, and we make allegation that MLA and MP, they pressurize the respondent number 1 and 2 and then order is passed. When you are making an allegation against a person who is not party to the petition, the petition is not maintainable. Courts are entertaining, that is altogether different thing. But law is this, that if you make allegation to the person, he is a proper party. Reason is this, if the allegations which are made against this person goes unrebutted on a record, there is a prejudice caused to that person, and therefore when you make allegation, there should be opportunity given to that person, and therefore those persons are necessary party. What we are finding in my petition, in my office a petition is drafted, whenever I make an allegation against MP, MLA or minister, I always make him a party. But then court would ask the government pleader that issue notice to him or not. That is not a practice. If there are allegations, notice should go to him. He should reply the practice, because not only practice, it is a set. That when you are making an allegation against, then he is a proper date. This is our statement. There should be a particulars given stating that in a pleading that respondent number 1 or 2 has given a notice on so and so date, calling upon the petitioner to explain all these things, and the particulars are 1, 2, 3, those should be mentioned in a petition so that you can refer the document. It is not necessary that you should translate entire document and plead in the petition, not necessary, that is not requirement. Material things are to be explained in the petition. Then if there is a malice, we find several times that when we file a petition, there is always interference by a politician, and we make allegation that MP, they pressurize for a senior division. We are filing a petition before a cooperative court. So therefore, we mention, and first we have to think of why we have to approach to the cooperative court, why we have to approach to the high court. That should be always kept in mind. Then a proper parties. There are two things. The petitions are dismissed on non-joinder of necessary parties. Certain times unnecessary persons are made parties, and misjoinder of parties, the blame is on a petition. And therefore, there are two things, that a party against whom relief is sought is a necessary party. Party whose presence for a decision, just decision, is necessary is a proper party. This we have to consider, that against whom relief is sought is a necessary party, whose presence is required is proper party. Then as we know that unless there is a name of petitioner and respondent, but the respondents are to be selected as said by me. If a petition is minor or the respondent is minor, then we have to take care. Minor cannot be prosecuted, or a minor cannot be sued, or we cannot sue through a minor, and therefore a care is to be taken that person or the legal guardian of that person should be there as a petitioner, a petition is to be always filed through a legal guardian. Then there should be a clear-cut mention that court has jurisdiction. Cooperative court, when we approach to the cooperative court, we have to spell out that why this court has a jurisdiction. When we are approaching to the high court and blindly, since other persons are following, because in high court, alternate efficacious remedy, and therefore we are approaching to the high court. In fact, this pleading should be, if we approaches to the high court, after availing all remedies, those are to be stated in the petition that these were the remedies available, and after exhausting all remedies, we are approaching to the high court. There is second thing. If I have to approach to the high court directly, I have to state in the petition that in clause number so and so or in section number so and so, there is a remedy of appeal or a revision. It is available statutorily, but it is not efficacious remedy. And why it is not efficacious remedy, that is to be stated. For the on the direction or as per the directions of his superior, and therefore I lost an opportunity of my appeal, that statement is to be made in the petition. Then what is the requirement is material facts and material particulars. If we consider the criminal law, fact in issue, or in evidence act, fact in issue and relevant fact, that is the requirement of pleading. When you are alleging something, all materials connected with that is to be placed along with your pleading before the court. Therefore, material facts and material particulars are to be pleaded. Then reference of a document. As I said, that how the document is to be referred in a petition. When you are referring a document, date, what is it about? That description in a short should be referred in the petition. Therefore, without going to that annexure, judge should be in a position to know the nature of a document. That is the requirement. Then if it is a writ petition, there should be a separate ground set out in the petition. As I told you that my petition was dismissed by the learned Chief Justice on the ground that there are no separate ground set out. And the important aspect is prayers sought. Now, when we think everything about the petition, but the precise relief for what purpose we are approaching, that is very important, relief sought. As per the High Court directions, we are required to provide a synopsis. Now, what we are doing, I'm not blaming anybody, including me, either index is converted in a synopsis or petition is as it is our synopsis. That is not a practice. A synopsis is a brief idea, and why it is there. Other day I was hearing the Honorable Justice Oak on YouTube. When he was elevated to the Supreme Court, and there was a conversation with the Supreme Court lawyer, what is expected by the judge from a lawyer, because advocate on record, he was addressing to that community of advocate on record. And he made a mention that I was sitting at Aurangabad when I was a judge of High Court, and I was given assignment of a second appeals. He made mention that at least 200 matters were listed before him every day. But he frankly admitted that it is not possible for a learned judge to read all the papers. But the judges claim that they have read. After that judge came, read everything. And then 41 matter he has not read. But he will immediately ask that what is the substantial question of law involved in a matter. And then it would be very difficult for a lawyer to answer immediately. And then judge would say that there is nothing in your matter. Matter will be dismissed. He was addressing that you should be prepared that what is important. You should be in a position to tell the judge that this is important in a question of law involved in my matter. And he gave a clue that we do claim that we read all the papers. That is not a correct position, and he was referring specifically Aurangabad bench. And I was very happy that when he referred and told all the experience at Aurangabad bench, there are two sections of his speech. If you go to YouTube, you will find that there are so many things told by him in respect of this synopsis, prayers, then the grounds, how it is to be read, and what is the expectation of a judge. Now, we have all technology. Now, what we are doing is, we started cut paste. Cut and paste. Petition is ready. The Supreme Court noticed in 2022 and said that this cut and paste drafting practice is not permissible, because each petition has its own life or fate, and you have to make a petition on the basis of instructions. Therefore, don't follow this practice as said by Supreme Court in 2002. There is a reported judgment on this, that this practice is deprecated. The Supreme Court rejected so many petitions on the ground that petitions are frivolous because of faulty pleadings. In 2013, there is a judgment. Supreme Court dismissed the petition, saying that no sense is made out from the petition, or nothing is there. Now, this should not happen, and therefore we have to take care of this. Justice Krishna Iyer, in a case of Madhavrao Shinde, has remarked that pleading must reveal the real nature of a controversy, helping the court navigate through the fact and legal position. This should be the petition. Justice Ravindran clarified that we have a different litigation. Whatever I have stated earlier is a general, nothing to do with a specific pleading in a specific matter. For example, we are filing a second appeal before the court. Whatever earlier I have stated is useless. You need not plead any particular facts and law. What you have to do is, what is the substantial question of law involved in the petition is to be pleaded. All facts, all things narrated earlier has no importance. And therefore, a petition, what sort of a petition is being presented before a court is very important. What is the requirement of law? And therefore, when we draft a second petition, section 100 is to be kept in mind, that what is the requirement of second appeal. The second appeal is only for the purpose of substantial question of laws, and we have to frame. Now, I have seen certain second appeals, one-page second appeal. Name of the parties being agreed by the judgment and order passed by two courts below. These are the substantial question of law. 1, 2, 3, 4, appeal is over. Because in second appeal, no prayer is to be made. That we know. And therefore, this is second appeal in 1 or 2 pages. No further requirement of, but essential parties, you have to focus on the, what is the requirement. Take example of a civil revision application. Now, what is the civil revision application we file? What are the grounds which are stated under section 115 of CPC is important? Jurisdictional error of the trial court. Now, we know that jurisdiction is vested with the civil court is not doubted by anybody. Jurisdictional error means the facts which are required to be considered are not considered. The facts which are not, which are ought to have been considered are not considered. This is an error of a jurisdiction, and on that basis you have to file your petition by detailing everything. No further, all earlier what I have said is not material for the pleading of this civil revision application. The first appeal, how you will draft first appeal. What is said is, the first appeal is a continuation of a trial. Even in first appeal or in a criminal matter, it is a continuation of trial. For our sake, we have to take out the grounds. Normal grounds are, the trial court has erred, not appreciated proper evidence, lost sight of the fact, and therefore judgment is perverse. These are the common grounds. You go any first appeal, these are the common grounds. That is, When we are filing a review application, Order 47, Rule 1, what is the requirement? Whatever I have said earlier, or the first appeal, second, that is not a requirement. Under Order 47, Rule 1, total different approach. If there is a judgment given by the High Court or any court and you are approaching for a review before the same court, you cannot argue the matter as if it is appeal. You have to point out apparent mistake on the face of record. Unless this requirement is satisfied, your review will not be entertained. Therefore, in each proceeding, there is a different ground and you have to focus on that ground for the purpose of your pleading. There cannot be ideal one petition for all purpose. There can't be. And therefore, we have to consider this. We are filing a delay condonation application every day. And nobody is considering what is Section 5 of the Limitation Act where delay is to be condoned. We normally file that there is a 60 days delay. Supreme Court says that you have to explain a delay of each days. We are bringing certificate of medical officer, or we say that he is very poor coming to the city, he met the lawyer and then there is a delay. Sufficient cause is very important, and that sufficient cause is to be pleaded when we are filing an application for delay condonation. All other facts may be there, may not be there, but what is a sufficient cause for condonation of delay, that should be pleaded. And on the basis of that, there can be a decision. Nowadays, we are, for the reason stated in application, delay condonation application is allowed. That is the standard order which is passed. But when matter is contested on merit, the result would come on merit. I had contested one matter on merit. There was a 60 or 70 days delay. A teacher approached to the court and there was a 60 or 70 days delay. He said that I was not well and these are the certificate of doctor. And then we filed a reply because our client wanted that there should be a reply. We filed a reply. During these 60-70 days, he is claiming that he was ill, he was not well, he was advised by the doctor to take rest. But during this period, he contested the election of a legislative assembly. He was canvassing. And then court said that false ground is no ground for condonation of a delay. There should be sufficient ground. And then it was rejected by the High Courts, relying on a Supreme Court judgment saying that you have raised a false ground. So many writ petitions filed. Many of us, including me, we do not know the nature of writ which is to be sought from the High Court. Suppose there is a termination order passed by an executive and we approach to the High Court saying that there is no alternate remedy. Quash the termination order. What would be the nature of writ petition? I find in so many cases, because I was an assistant government pleader and I raised so many objections on this, and therefore I studied this. Which writ can be issued? Normally, answer would be writ of certiorari. Normal. But in my opinion, this is not a correct. Correct is writ of mandamus. Again, there would be a question mark. That how writ of mandamus you are saying, because order is to be quashed and set aside, and this can be done under writ of certiorari. A writ of certiorari can be issued only against a quasi-judicial or a judicial order. A writ of certiorari cannot be issued against executive. This is a settled principle, and if we consider this, then when termination order which is passed by executive cannot be set aside by exercising a writ of certiorari. A habeas corpus petition is of a criminal nature. Criminal bench deal with. What is the requirement? That person is illegally detained. Now I may tell you, in the last 2 weeks I fought one litigation of detention, illegal detention under the local act. A person was detained for a year. My colleague prepared the petition and he made the prayer to set aside the detention order passed by the executive magistrate. And then I corrected that there should be a prayer of habeas corpus also, because I had studied this, that setting aside order is one thing, all right, but in all detention matter, it is a petition for a habeas corpus. I'm not advising you, you should make prayer like this, but law is this. I made that prayer along with one more prayer that quash and set aside. The first question came from bench. Why prayer clause A, writ of habeas corpus? And I was interested in getting my petition disposed of as early as possible. Therefore, I made a request that I'll delete that prayer. I have not argued before the court. My lord, this is a prayer correct as per Supreme Court judgment because my second prayer was there and my petition was is like a supervisory jurisdiction of High Court under Article 227. There is a lot of debate on this, that Article 227 is having a supervisory jurisdiction over the courts and subordinate courts and tribunal. Then what is the nature of writ of certiorari? It is akin. But when matter is heard by 226 and writ of certiorari is asked against the order, what is observed is whether proper procedure is followed or not. There cannot be a writ of certiorari in the nature of appeal. We are doing that. Courts are entertaining because there are several reasons also. Some orders are perverse. Law is not followed. But whenever judgments come from the Supreme Court is very keen on this, that writ of certiorari, whether the trial court or the tribunal has exercised the jurisdiction which is vested in them properly. And that proper is as per the law, which is, we raise several grounds that notice is not issued, then principle of natural justice is not followed. All these grounds are always available in writ of certiorari also. Writ of prohibition, altogether different nature. We approach to the court and we make a request to the court that prohibit that authority from exercising the jurisdiction because that authority has no jurisdiction. There are two things. If order is passed without jurisdiction, we come to the court saying that the authority has exercised the jurisdiction which was not vested. Court can entertain. Writ of prohibition is before exercising the jurisdiction by that court. This writ is almost not entertained nowadays. But this is a writ of prohibition which is essential. If a court is satisfied in a proper case that the authority or the executives are proceeding without power in law, writ of prohibition can be issued. And the last is writ of quo warranto. This writ of quo warranto is, it is never issued against the government or an appointing authority, but we seek that writ. No issue. Writ is always sought against that person who usurped the powers. For example, XYZ, I had filed a petition against the CEO of work board that he was not appointed properly and he is not satisfying the requirement. He is not holding the post of additional district, level of additional district judge at that time. And therefore, there was a writ sought. Writ is sought and explanation is asked to that person who is usurping the post. But normally, you will find a judgment that when we seek a writ of are giving me this opportunity, I express my thanks to the managing committee as well as I express my thanks to all because I made you to sit and hear compulsory. Thank you.
Thank you, sir. That was very informative and insightful lecture. And for enlightening us on a very basic and in very simple language, how drafting and pleading could be made in a simple. Indeed, we will try to follow your suggestion and tricks in legal drafting and pleadings. Now, moving forward with the program, I call upon Mr. Avinash Borulkar, sir, President of our bar, to address the presidential address. Please.
व्यासपीठावरील आजचे वक्ते सपकाळ साहेब आणि उपस्थित वकील वर्ग, मी भाषण करण्यासाठी आपणासमोर उभा नाही आहे. तर सर, एक अध्यक्ष म्हणून एक सांगू इच्छितो की आज सभागृहात जे आम्ही उपस्थित आहोत सगळ्यांतर्फे आम्ही अशी देतो की जे आपलं ड्राफ्टिंग अँड प्लीडिंगवरचं लेक्चर ऐकल्यावर भविष्यात कोणाचंही फेल्युअर आणि लॅक ऑफ प्लीडिंग म्हणून कोणाचंही मॅटर डिसमिस होणार नाही एवढी मात्र आज वकील हजर आहेत त्यांच्यातर्फे मी सांगू इच्छितो. आणि जसं आपला वकील सभासदांसाठी जे वेगवेगळे जे कार्यक्रम करत आहे, जसे लेक्चर सिरीज आहे, ज्ञानार्जन करण्यासाठी आपणासमोर हे वेगवेगळे लेक्चर सिरीज आयोजित करतो आहे. त्याचबरोबर आमचा दुसरा एक मानस आहे की सांस्कृतिक कार्यक्रम देखील झाले पाहिजेत. त्या उद्देशाने आता नुकतीच आपली दिवाळी सुरू होणार आहे, तर दिवाळी पहाट म्हणून एक कार्यक्रम आयोजित केलेला आहे. दिनांक 26/10/2024 आपला जे हायकोर्टाचं प्रिमायसिस आहे, लॉयर चेंबरच्या इथल्या जागेमध्ये हा मैफिलीचा सुगम संगीताच्या मैफिलीचा प्रोग्राम आहे. फक्त एवढंही तुम्हाला कष्ट घ्यावं लागणार आहे, सकाळी उठून लवकर यावं लागणार आहे आणि त्या कार्यक्रमाचा आस्वाद घ्यावा लागणार आहे. तो आपल्या सर्वांसाठी आहे. तर सर्वांना विनंती आहे की आपण या कार्यक्रमासाठी हजर राहावे, उपस्थित राहावे व त्याचा आस्वाद घ्यावा. धन्यवाद.
Thank you, sir. As we proceed to conclude the today's program, now I request Advocate Vishweshwar Pathade sir, Library Secretary, to address and deliver the vote of thanks.
आलेला आहात. संत ज्ञानेश्वरांनी त्या ठिकाणी ज्ञानेश्वरी सांगितलेली आहे. त्यामुळे आपले वकील संघाच्या वतीने आभार व्यक्त करतो. त्याचप्रमाणे या व्याख्यानमालेसाठी उपस्थित असलेले सर्व ज्येष्ठ विधिज्ञ वकील बंधू भगिनी यांचे वकील संघाच्या वतीने आभार व्यक्त करतो. तसेच हा सुंदर असा कार्यक्रम आयोजित करण्यासाठी हे सभागृह आपल्याला उच्च न्यायालयाच्या प्रशासनाने उपलब्ध करून दिले, त्यांचेसुद्धा मी वकील संघाच्या वतीने आभार व्यक्त करतो. त्याचप्रमाणे फोटोग्राफर आणि सर्व माझे कमिटीचे सदस्य यांचेसुद्धा मी आभार व्यक्त करतो आणि कार्यक्रम संपला असे जाहीर करतो. धन्यवाद.